Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. Earlier this week, there is a certain congressman from Tennessee, whom I'm not even going to identify by name, who said that Muslims don't belong in American society. I'm reasonably sure that he said that, not because he even necessarily believes it, but because he wants a moment in the sun. He also said it because that even if he doesn't necessarily believe it, he knows that there are a lot of people out there who do, and he is looking to capitalize on their bigotry and their hatred in order to score points politically. I mean, that fact alone probably warrants its own conversation. It might be the topic of a follow-up video. But for today, I just want to focus on the fact that he is dead wrong, not even as a matter of constitutional law, but as a matter of historical fact. I mean, the fact is that Muslims were not outside of the founders' thinking when they designed the American system of religious liberty. The founders, in fact, specifically included Muslims in the idea of religious tolerance in the United States. Now, that's certainly not to say that the idea of religious bigotry started recently. Quite obviously, religious bigotry has been around since the dawn of time. But the founding fathers of the United States, the intellectual force behind our Constitution and our way of life, believed and firmly knew that Muslims were included in our idea of religious tolerance. They were included in the Free Exercise Clause and the Establishment Clause of the First Amendment. In terms of committing the meaning of America and its way of life to paper, there are no founding fathers more important than Thomas Jefferson and James Madison. Thomas Jefferson wrote almost all of our Declaration of Independence, and James Madison was the principal architect of the U.S. Constitution. Just as an aside, they also happen to be very close friends. They lived relatively close to each other in Virginia, and they definitely corresponded with each other. And the historical record is quite clear that they had a lot of intellectual influence on each other. The historical record shows that in 1765, when Thomas Jefferson was a young law student in Williamsburg, Virginia, he purchased a 2-volume English translation of the Qur'an. The translation was by a gentleman named George Sale and was widely used by scholars in the English-speaking world. Now, Jefferson didn't buy a copy of the Quran because he was Muslim. He bought it because Enlightenment-era scholars studied religion comparatively, especially religions that shaped law and politics. Jefferson's Quran became part of his personal library, which later formed the foundation of the Library of Congress after the British burned Washington, D.C. in 1814. But Jefferson's interest in Islam wasn't just an academic curiosity. During the late 1700s, Americans were debating a fundamental question. Who exactly does religious freedom apply to? Again, there were bigots out there at the founding of America who believed that the new nation should protect only Christians. But others, including the most prominent members of the founding generation, argued that true religious liberty had to extend to everybody, including people whose religions many Americans didn't understand or even like. The general philosophy was that if the Constitution could suppress any religion, there would be arbitrary lines drawn between them. Consequently, religious freedom had to mean total religious freedom in the United States. In fact, they specifically used Islam as the test case in a lot of their rhetoric. At the time, they referred to Muslims as Mohammedans. Now, among legal historians and legal scholars, it's pretty well known that the First Amendment, especially the religious clauses of the First Amendment, draw heavily on Jefferson's Virginia Statute for Religious Freedom, which passed in the state of Virginia in 1786. Again, the religious bigots at the time asked whether the law would protect people who were not Christians, people like Muslims. Jefferson was explicit about who he intended the law to protect. He said, and I quote, "The Jew and the Gentile, the Christian and the Mohammedan, the Hindu and infidel of every denomination." In other words, religious liberty wasn't supposed to be limited to Christianity. Jefferson emphatically believed that religious liberty wasn't supposed to be limited to Christianity. It was meant to apply universally. James Madison took very nearly the same position. In his famous Memorial and Remonstrance against Religious Assessments in 1785, Madison argued that religion must be left entirely to the individual conscience. Government, he wrote, has no authority to control religious belief. His philosophy directly shaped the First Amendment, which prohibits Congress from establishing a religion and protects the free exercise of religion. But even before the Bill of Rights was passed, the main articles of the U.S. Constitution indicated an underlying philosophy of religious tolerance. Specifically, Article 6 says that no religious test shall ever be required for public office. And that was a radical idea in the 18th century. In most of Europe at the time, people were barred from office unless they belonged to the official state religion. The United States explicitly rejected that model. A Baptist minister named John Leland, who helped persuade Madison to support strong religious liberty protections in the draft Constitution, argued that government must protect the freedom of, and I quote, the Jew and the Gentile, the Christian and the Mohammedan. The message was clear. If liberty applied only to the majority, then it wasn't really liberty. And these concepts were reinforced later in early American history after the establishment of the Constitution, but while this founding generation was still alive. In 1779, during the presidency of John Adams, the United States ratified the Treaty of Tripoli, a diplomatic agreement with the Muslim state of Tripoli in North Africa. The treaty was approved unanimously by the U.S. Senate, and it contains a rather remarkable statement. In Article 11, it declares, and I quote, the government of the United States is not, in any sense, founded on the Christian religion. Period. End quote. That line was meant to reassure Muslim governments that the United States was not a religious state engaged in a religious conflict. It also reflects how the early republic understood itself. The American system was designed to separate government power from religious identity. That meant that the state would not enforce Christianity. And it also meant that people of other religions could participate fully in public life in America. And Muslims have been part of that American life for far longer than most people realize. Up to 20% of the Africans enslaved and brought to North America were Muslim, and many of them were highly literate in Arabic and came from sophisticated Islamic societies in West Africa. A well-known example was Omar ibn Said, an Islamic scholar from present-day Senegal who was enslaved in North Carolina in the early 1800s. He wrote an autobiography about his experience as a slave in Arabic, which still survives to this day. And that was just the beginning of a very long and storied history of Islam in America. Today, Muslims serve as doctors, teachers, soldiers, engineers, and public officials. There are even Muslim chaplains in the U.S. military. The upshot here is that the historical reality is straightforward and entirely contradictory to that jackass congressman from Tennessee. Muslims are not outsiders to American history. They are integral to American history. They have been part of the American story from the beginning, and the principles of the U.S. Constitution were written with religious diversity in mind from the very beginning. Understanding that history helps us understand what the founders were actually trying to build: a system where government power does not decide which religions belong. This congressman, again, whose name I am not going to divulge, is a disgusting opportunist who needs to be removed from public life by any lawful means necessary.